Hi everyone and welcome back to our video series on recent data protection decisions from the Court of Justice of the European Union. Today I'm joined by my colleague Vivian Spies from the Technology and Innovation Department at Arthur Cox, and we're going to be talking about liability under the GDPR and in what circumstances a fine can be imposed for an infringement.
Thanks, Aoife.
So we all know that supervisory authorities are continuing to levy large fines for infringements of the GDPR. Can you tell us a little bit about the cases that we'll be discussing today?
Sure. The first case we'll be discussing is case C683/21, which was handed down on the 5th of December 2023. Here, the Lithuanian courts had referred several queries to the CJEU in relation to a dispute between the Lithuanian Public National Health Authority and the Lithuanian Supervisory Authority concerning the development of a mobile application to register and monitor individuals exposed to COVID-19. As part of the case, the court had to consider Article 83.2 of the GDPR, which lists the factors which the court must consider when deciding whether to impose a fine and the amount of such a fine. Notably, the court held that Article 82.3 of the GDPR only permits the imposition of a fine where GDPR infringement has been committed, and I quote, wrongfully by the controller, that is to say, committed intentionally or negligently.
Okay, and did the court consider what role processors might play here?
The court was asked to consider whether an Article 83 administrative fine can be imposed on a controller in respect of processing operations performed by its processor. The court held that as a controller is responsible and liable for processing which is carried out on its behalf by a processor, therefore a controller may have an administrative fine imposed on it pursuant to Article 83 GDPR, where it is the processor that carried out the relevant processing.
That's interesting. Did the court suggest that there was any limits around this?
Yes. The court found that responsibility and liability of the controller for the conduct of the processor cannot extend to situations where the processor has processed personal data for its own purposes or beyond the instructions of the controller. The court also found that a controller cannot be held liable where the processor processed data in a manner incompatible with the arrangements with the controller. The court referred to Article 28.10 of the GDPR, which provides that a processor must, in this situation, be considered as a controller of such processing.
Thanks, Vivian. It is helpful to have some clarity on liability from the court. The second case we're going to be talking about today is case C807/21, or Deutsche Wohnen. Could you tell us a little bit about that case, please?
Sure. The court confirmed that for a fine to be imposed on a controller in respect of infringements under the GDPR, those infringements must be committed negligently or intentionally. The court elaborated the test for whether an infringement has been committed intentionally or negligently, holding that a controller can be penalized where that controller could not have been unaware of the infringing nature of its conduct, whether or not it is aware that it is infringing the provisions of the GDPR.
Okay, so in other words, a controller won't be able to rely on a defence that it didn't know that its conduct was infringing the GDPR in circumstances where it could not have been unaware that that was the case.
Exactly. This really highlights the need for controllers to stay on top of their GDPR compliance efforts and to ensure that they're in a position to be able to demonstrate and justify why they have adopted a particular approach to a specific data processing operations in case a supervisory authority comes knocking.
Thanks a lot, Vivian, and thank you all very much for watching.